make her come down here. You've got to fill out the form and then it gets approved or not.
Okay.
Okay, so.
Your Honor, at that point in time, a judgment can be entered, even if.
Yeah, I mean, a judgment can enter, but I want to give the SDR process, because I have a feeling that the reason the SDR, part of the reason that was denied is because it wasn't sustainable.
Mm-hmm.
And that's not the case, because now with the adjustment.
Yeah, and it also wasn't the correct balance.
Correct. So that's what they did. And so, yeah, maybe I'll give a judgment, maybe I won't. I can't say, but I think I gotta give her a fair shot to try to get the assistance she can. If she surrenders possession, then in essence, she's giving up her right to any unit. That's what the problem is. So I get why it's where it is. So.
Judge Raven Walker, Derek had to run to the restroom.
Okay. All right. And Raven Walker. All right. Where are we on this case?
Well, Your Honor, I understand that this matter's been adjourned a few times for them to try and speak with Hawk.
Correct.
And it's further my understanding after speaking with the defendant that she did speak with Hawk, in that their position is that they will not approve her for any amount at this time because the balance is too high.
I do want to say something.
Absolutely.
Counsel, I really just called Hawk in the hallway. Just to tell him I'm at court and what's going on. Derek just started a job and they told me that he made too much so that they can't help me and give me an appointment. She said that his amount that he makes per hour and weekly is above the HUD limit, so she can't help us. So, not to cut counsel off, but counsel and my landlord was gonna allow us to pay that balance that that $1,400 for 6 months, $240 a month. That's what he was gonna allow if Hawk would pay the $3,000.
If the Hawk would pay the $3,000.
So now we're kind of in a rut.
But unfortunately, if I understand you right, they're saying that it's not so much that the balance is too high, it's that your income is too high. So
No, the first one was right. The balance was too high. She couldn't help me. But now when I just called back a minute ago in the hallway and told her about us having employment, she said then she did the numbers. She said that he made too much for them to help us to get the appointment.
right, so apparently they're not going to get approved.
So you gave her the numbers of what he's making now.
Mm-hmm. And she said that I told her, I said he just started the job Tuesday. He doesn't even have a check yet. But she asked her how amount he gets an hour, and then she did the math and she said, well, according to the HUD requirements, you guys make too much to get the appointment. And the appointment, I wasn't going to be able to get
The
that
HUD requirements.
Yeah, that's what she said. And if you got the person from Hawk on here, I'm pretty sure they put it in my notes because I just got off the phone with her. And I didn't understand that because, like I said, he doesn't have any check stubs yet. He just started, so I really don't know.
Okay. So landlord's willing to agree to a payment plan, right?
Yes, sir.
But in order to fulfill that payment plan to the landlord, presumably, you'd have to be working.
He's working.
I got it.
I'm still waiting.
But now, so you can do that part of it. He then makes too much money to get the $3,000.
Yes, sir.
So somebody's gonna have to get me an answer on this. I hear what you're saying. Because at some point, if he were to quit his job,
It would go back to zero.
he would go back to zero, but then the issue would be, the housing isn't sustainable for your family. So then they're not gonna pay. So folks, let me ask you this. How are you going to, okay, let's say everybody got you out of this hole. How are you gonna pay your rent going forward?
Well, right now our rent is at 0. So when he gets a certain amount of check stubs, that's when they'll start back charging us rent. And he has to turn those into the,
So your rent right now is 0.
yes, sir.
So
Well,
no.
just to put you up on why this is even happening, they didn't recertify us at the correct amount of times when he was working and did give the check stubs. So all of this is a backup of what they didn't put inside of the system. So now they're like, y'all owe us this. But he reported when he was supposed to. It just didn't get in there in time. They switched management and all different type of things was happening.
But is all of this then due?
Well, I was thinking the same thing, like, it accumulated over a period of time, and then they just told us like, hey, they start dropping letters on our door, like, hey, you got to pay this. And the numbers have changed.
But hold on a second. If he was working, you reported that income.
Yes, sir.
Did your rent go up when he did that?
No, they never.
That's just answer.
Sorry.
Simplest answer, sometimes the best thing. So rent didn't go up. When did that start?
We never actually got an amount to pay. That's why we're here. We never actually got an amount to pay because he didn't keep the job for that long. So we went back to 0. But when he did have a job, they didn't put the stuff in so we could pay monthly.
So when is all of this coming from? This amount?
This is from months before when he had a job.
Let me ask it this way. How long has your rent been at 0?
Since October. Recently, since October.
So this amount is from prior to October?
Yes, sir. I believe. Or sometimes before that. But I just know that that how we even got all this amount, period, because when we would go into the office, it was just paperwork that wasn't processed. So that's why we have such a big amount. It'd have been different if they gave him an amount to pay every month and then we didn't pay nothing.
Ma'am, sometimes you just need to be quiet.
I'm sorry.
So I have a rental rate of $534 per month. Which when I look at all of this, equates to 9-10 months that isn't paid. All in 2024. But that's not gonna match up if the rent is 0 in October. Well, it could, I guess, but that's kind of weird. And Counselor, I'm just going by the complaint because the complaint indicates that basically they're paid through the end of 2023. It states in paragraph 5 that their rent is $534. They say that in November of 2024, that does not match with what the defendant is saying is that the rent is 0.
Your Honor, I can represent to the court that their rent does change. In February, they're paying $994, March $994, April $994.
$994.
$1,444. Same as in June. Same as in July. August, 1,312. September, 1,312.
So hold it. This is what their rent that they're being charged.
Yes, but then there's also billing corrections. I guess I need my property manager here to explain it all to the court. That's what the.
Yeah, because something, I mean, I'm not digging deep, but I'm listening to what defendants are saying. I'm also just looking at the complaint and just from a rudimentary standpoint, all the math does not add up. I'm unclear how they get there, how that number gets there. And then, I don't know if that number is incorrect. But then the other part of it is you have section A
through the Sycamore Meadows.
through Sycamore Meadows. Because the other part of this is, now, have you talked with legal services regarding this? Or
They said they couldn't represent us because they had too many cases for Sycamore Meadows. Miss Emily.
that's not correct? What happened?
What's not correct?
Here's what I'm worried about.
I have a text message.
Hold on. Would legal services be willing to talk to, I mean, here's my problem. My problem is I've seen enough Sycamore Meadows cases and there are recertification issues. And I'm not saying that this is one, don't know, but it looks to me like it's one. Ms. Lee, you are just nodding at me. I don't know what that means.
All right, I can speak. We've been attempting to advise all of the residents at Sycamore Meadows. We don't
Right.
commit to actually representing each case because we don't have the capacity. But we're absolutely going to continue advising the defendants in this case. Our impression was that they did not want further assistance. But if that's not true, we'll have to come again.
I had turned in like all the documents that I had for
What?
I had turned up all of my documents that I had from the last management to now the new management. And I had gave all those documentations to Emily. And when we were supposed to be here the first time, she told me at the last minute saying that she couldn't represent us. So it completely just wasted our time because we was already nervous of approaching.
Hold on. Who's in?
Emily is our fellow that's been appearing to be your honor.
Okay.
Right, and the thing about legal advice, what more do we need to get advice to tell you? Because all we're doing is telling the truth, so what else do we need to say? Because the only thing that could change it is if the manager explained why the prices keep going up and down.
So maybe if you have that attitude when you're talking to a lawyer, they will say, it seems like you don't want our help.
No, I didn't have that attitude. I'm just frustrated now by saying it, but I didn't have that attitude. I didn't do the talking, he did the talking.
Well, that may have been a problem too. So listen. All I'm saying is, I'm telling you what I see on the surface when I'm looking at this. I don't know any of it to be true. But if it's a recertification issue, it changes what it is. But you guys having been here, maybe I can understand Emily's position. You guys have to listen to what they're telling you. Because you can tell me all day and night long, he didn't have a job, he didn't have this, it was zero, it was whatever. But I don't have the research documents. And I'm not gonna go through the research documents. That's what other people have to do to present to the court. Right? So if they're in a position of advising you, I think you need to listen to what they're telling you and follow their steps. Something tells me that wasn't done.
Well, I won't say that we wasn't following their steps. We gave them what they asked us for. And then the day that we were supposed to go to court, she texted us in the morning and said that she could only advise us from there and to tell her what was going on, whatever you tell us to tell, to have that conversation. It's
Did you do that?
No, sir.
Why? If a lawyer told you, okay, we can't represent you, but we can advise you, go to court, tell us what the court says, and then you don't, and tell us what the court says, send me that information, and you don't do that, what are they supposed to think of whether or not you need to be represented?
Well, I just thought because she said that she couldn't Go ahead.
Spoke to Emily, I told her what you had said. First time we met, she already had documentation.
Here's the thing, I'm not gonna go through all this. I'm just not. Do you want advice on this matter and the potential issues that might arise regarding a recertification? That's your call. If you want that, then I'm gonna grant one more week for you to try to get back in touch to try to make sure it happens. If you don't want it, then forget it. I'm not gonna worry about it.
Yes, I would want that to be properly.
Okay, but so I'm going to, over plaintiff's objection, adjourn it out 1 week so they can get advice, but I'm only doing it contingent upon the fact that you listen and follow that advice. Understood? You got to listen to what they say. They'll be more than happy to answer some of your questions, but you got to listen. You got it locked in your head as to exactly what this is. But I think, ma'am, I'm gonna be honest with you, I think you're wrong in some of what you're telling me. But I only say that because as I'm looking at it, there are a number of these cases that I've seen. And so I know some of the things that happen, but your conclusions of what it is, I think are wrong.
The only reason why I was telling.
So you want to now argue with me?
No, I'm not
I've
arguing.
been practicing for 40 years.
I'm not arguing.
Want to argue with me? I just told you what I said. I'm done. You can talk to legal services, get advice. January 31st, 2025, what time? 12 p.m. Thank you. No, I'm not giving you your file. No, this is the whole thing. Sometimes, it hasn't been 40 years actually, but almost. Sometimes my dad used to say to me, you lead a horse to water, but you can't make him drink. But sometimes you need to lead a horse to water and you need to make them drink, so you dunk their head in. Just a thought. All right. Let's try this case. Okay, my dad never said that. That was me. Sycamore Meadows versus Christine Mason.
Christopher Asphalt for the plaintiff.
Hello.
Hello, Miss Mason. All right, where are we on this case?
Your Honor, we've agreed to adjourn for a week because Mason has patched together almost all of the balance with rental assistance. We need to review the ledger. We're waiting on one recert. We want to make sure that we know exactly what the balance is. And then I have one more resource I'm going to reach out to try to get the remaining balance covered. If not, Ms. Mason is waiting on one W-2 to apply for taxes, and with the balance that would be left over is not significant in regards to the total balance. So she would be able to pay off whatever she owes from her tax return. But we need another week to look at the documents and make sure everything's correct.
Any objection from plaintiff?
No objection, Your Honor. I just wanted to clarify two things. The defendant did make a $600 escrow payment today to the court. Well, you don't need anything from us at this time to complete.
We thought we were waiting on the 2022 research document. We reviewed her case, the detail that we had, because we thought we were waiting on that. I was just informed today at court that that document does not exist. So now we just need time to go over what we do have and
Got it.
first.
Okay. Yes, I have, my total 1,000 even in escrow.
1,000 even in escrow?
Yes, yes, sir. January 31st, 2025, 12 noon.
Thank you.
Thank you, ma'am. Sycamore Meadows versus Tamara Jackson.
For asphalt for the plaintiff?
And no.
I wasn't sure what
She-
that
no,
meant.
she She said, no, what, we gonna fight? No, that's what she was, I'm just saying. How I saw it. Hello, ma'am, what's your name?
Tamara Jackson.
All right, where are we on her case?
Your Honor, I was not able to speak with this defendant, but the good news is that I understand she did recently receive an adjustment or a recertification or some type of payment that brings her balance down to $418. Does that sound accurate, ma'am?
Yes.
That's what her balance is, 418.
Yeah. Can you pay that by February 3rd?
Well, I had to wait for DHS to, I guess, cancel out the other SCR so I could do my new one for the new balance.
Okay.
So I assume so. I'm hoping so by the 3rd.
Okay, so what's your monthly rent?
$14 now.
Huh?
Now it'll be 14.
$14?
Mhm.
So you would just need to come up with what, 418 plus $14.
Mhm. And I have to fill out a new SCR because the old SCR was for the old balance. I think it was like 8,000 or something.
Okay, so how many people do you have in your house?
3.
Okay, so what you're looking to do is get an SCR
To
that's
cover the
gonna
balance.
cover that amount.
Mhm.
Got it.
Your Honor, if we receive a notice of approval, they will honor that. They don't need to have cash in hand. She would just have to pay the bank.
Right, but I see what she's saying. She's got to get this new balance in because
Mhm.
the old balance. Did you get a denial off?
I
of-
did. I got
You
one
got a
this morning.
denial off of the old balance.
Yeah, I got a denial offer this morning. I talked to my caseworker last week, so they told me just wait for the denial
And
and then
then
fill out the new one for the
Got
new
it.
balance.
Okay, so what I'll do is this. The balance isn't that high and, yeah, I'm gonna do it this way anyway. February 14th, 2025 at 1 PM.
Can I do a Zoom?
No, make her come down here. You've got to fill out the form and then it gets approved or not.
Okay.
Okay, so,
Your Honor, at that point in time, a judgment can be entered. Even if.
yeah, I mean, a judgment can enter, but I want to give the SDR process, because I have a feeling that the reason the SDR, part of the reason that was denied is because it wasn't sustainable.
Mm-hmm.
And that's not the case, because now with the adjustment.
Yeah, and it
of
also
numbers,
wasn't the correct balance.
correct. So that's what they did. And so, yeah, maybe I'll give a judgment, maybe I won't. I can't say, but I think I gotta give her a fair shot to try to get the assistance she can. Okay, all right, thank you.
So the 14th,
Yes,
and you said what time?
1 p.m.
1 PM.
Thank you.
Thank you, ma'am. Sycamore Meadows versus Kayla P.
For asphalt for the plaintiff.
Jill Bauer for Ms. P, Your Honor, I am going to enter an appearance this afternoon after court. Well,
Oh,
actually, by Monday morning, get out soon.
all right,
Caleb P.
all right, where are we on this case?
Your Honor, legal services has not received any of the paperwork for this case yet. I requested it by email and haven't received it yet. Mr. Asphalt did say that he would get it to me, but this is a complicated case. It's
Anyway, it's a fire unit.
it's
She's,
a termination of tenancy case, and I need time to investigate and file either an answer or a motion.
But she's not in the unit.
No, she's not.
They filed a health claim.
Yes. She's zero rent.
But you're no longer in a Sycamore Meadows unit.
No, sir, they didn't rehouse me.
Pardon?
They didn't rehouse me.
Yeah, she's been unhoused since the fire on November 14th.
Yes, sir, and I signed my new lease on that same day before I discovered the fire.
And I've made requests for her to be rehoused and they've been denied.
Okay. When do we want to put it to?
I'd like at least 3 weeks to be able to go over all of this is very complicated. There's a lot of evidence and I want to.
You always tells me everything's complicated.
Your Honor, if the court wants to do that, I would request that she file some type of brief, laying out what the issues are, because I think it's pretty clear. And also, I think that in this case, an escrow order would be appropriate.
She's zero
There's
rent.
Pardon me?
Her rent is zero.
Right, but I mean, every month that we can't use the property, it costs my client money. And it's also causing, even more to the point, it's causing.
So,
damage.
hold on, counsel. If her rent is zero, and you want me to set escrow, what would I set her rent? What do you suggest?
Yeah, I guess
Set the escrow rent.
I didn't realize that her rent was zero. I think my client is more concerned about the damage that is accumulating to the property that's just sitting there in the severely damaged position that it is in. And if she's not even living there, I really don't understand. I mean, this case is just about possession. She doesn't want possession of that unit. In the meantime, somebody's paying for this unit. I mean, we're not seeking a money judgment. It's,
Well, why? Then explain to me, okay?
if they feel that she's entitled under the lease to another unit, then they should file some type of action stating that. And if she's been entitled to it for the last 3 months, then maybe my client will have to pay, although if her rent's zero, but my point is just simply, Judge, I don't understand. This case is about possession. She's not in possession. She doesn't want possession. It would be better for everyone.
No, I think she wants to be housed.
Yes, Your Honor.
Just my thought.
Yes,
So she wants to be housed, can't live in the unit that she's in.
correct.
And so therefore, she probably wants a unit.
Yes.
Right, but nobody wants possession of the burned unit. If they feel like they're entitled to another unit, then
But,
they should file
but
something.
hold on. If she surrenders possession, then in essence, she's giving up her right to any unit. That's what the problem is.
Yes.
So I get why it's where it is. So. Has it, the basis or what happened with the fire? Tenant's fault, landlord's fault, or undetermined?
Your Honor, I believe even though the fire report says that her cat started the fire.
Her cat.
Yes, I examined.
Her cat?
She was not at home.
Her cat
Her
started.
cat. I examined.
That's why I've told my cats, always stay away from matches.
Then
I don't
the
let them play
stove-
with lighters. I just keep them all in one spot because they could do that. I'm kidding.
One of the things that I want to investigate is how reliable that report is, because the stove that she had, and the knob has to be pushed in and turned. I don't believe a cat could turn on this stove.
Whoa.
So I think there's a problem with the theory of how the fire started. And Miss P was actually at the office doing her research for 2 hours while the fire started, so she wasn't home.
While the cats were turning knobs on a
Yeah,
kitchen.
yeah. So there are issues with the with the theory of the case, and it's gonna require some work to get a handle on our.
Okay, so I see,
Yes.
so.
Judge, I mean, my client would be willing, I mean, if she's talking about now like hiring experts to a stove. I mean, if the court just brought up the issue of if she gives up the right to possession of this apartment, then she's giving up the right to claim that they have the obligation to house her in another apartment. I mean, we'd be willing to waive that argument. And if she wants to file a separate pleading, to go delve into whether or not we have the obligation to house her in a separate unit that can be preserved. But in the meantime, so the taxpayers aren't continuing to pay for a unit that's vacant and continuing damage to this unit that she clearly doesn't want and isn't living there. Give us possession of that unit, and then we can go forward with this idea of, is she?
Why hasn't
entitled to-
Metal just gone in and repaired it?
Exactly.
And then decide
Well,
who
we
has,
can't. I mean, if
why
she's,
can't you?
if she's willing to, because I mean, that's essentially taking possession of the property, Your Honor.
No, it's
I
not.
guess, if the court's willing.
It
to
is absolutely not, it's not the same.
All right, if the court's willing to make the ruling, I mean, obviously, we normally always want an order allowing us to go in unless the defendant has turned in her keys and given us permission. But sometimes on the record, if she's willing to state that it's okay for us to go in there and take possession essentially and start making repairs, that would be.
Why can't the parties stipulate to allow the repairs to the premises?
Your Honor, we were never asked to, and actually, one of the issues is they've been very, they've given her 1 hour to remove all of her belongings from the unit. Once she has her belongings out of the unit, or if they can work around her belongings, the fire was only in the kitchen area, we would be happy for them to repair the.
That's fine, I'll prepare an order.
Everybody is making this harder than it has to be.
I'll prepare an order, giving her a certain amount of time to remove everything she needs out of there. And then after that time frame, my client can go ahead and take possession. Can we have a 1-week adjournment just to make sure that we're in agreement with that order?
Your Honor, we're not agreeing to them taking possession. We're in agreement with allowing the repairs to begin.
Well, I mean, yeah, I guess.
You guys
it's
are never
semantics, but I
gonna
mean,
be able to agree
I think
on
she
the
has to
language.
get everything out of there, right? Before we can do the repair.
Right, but I remember this, they were giving her a very small window to try to get stuff out. And putting a number of different restrictions on her entry, or at least as she perceived the instructions she was getting. I don't know if it was
No,
true.
they were
Right, I
restrictive.
think that has something to do with, because like the county says nobody can go in there. So I don't know, I guess I'll have to talk it over.
January 31st, 2025, 12 noon.
Your Honor, I just want to get clarification from the court that that's not going to be the deadline for me to file a response, correct? Because I don't have any of the
You
paperwork.
want it to be the deadline?
Pardon?
Do you want it to be? the
No, I
deadline?
would like-
Did I say it was the deadline?
No, I just.
Then it's
wanted-
probably not.
Okay, thank you, Your Honor.